pas commencé le streaming encore, mais je leur dis juste hello. If we will start. Good afternoon, everyone. On behalf of the European Composer and Songwriter Alliance, EXA, which represents 55 associations of music authors across Europe, it is my pleasure to welcome you all, here and online, to this conference on the implementation of the 2019 Copyright Directive. And let me first thank all our speakers for joining us today. This conference is organized with the support of the Creative Europe program, which has been essential to make it a reality. I would also like to express our gratitude to the Cultural Creators Friendship Group for supporting this event. As you know, this conference is co-organized with our friends and colleagues at the Federation of Screenwriters in Europe, the Federation of European Screen Directors, and the European Writers' Council. For a long time, our four organizations have worked together to convince policymakers to improve the contractual position of authors. Authors are, in their vast majority, freelancers who face precarious working conditions, low and unstable income, and a very weak contractual position. At EXA, a survey undertaken with our members in 2020 has shown that 74% of music authors cannot live off their artistic profession only. With Articles 18 to 23 of the Copyright Directive, this is the first time that the EU has intervened in the area of contracts. Why? Because contractual freedom is still a distant dream for a vast majority of authors. Take it or leave it is the rule, not the exception. Since the adoption of the directive, we have called again and again for an ambitious and faithful implementation. The directive has brought some improvements already, but much remains to be done to bring real and concrete progress to authors' contracts. When I was a young and, may I say, naive law student at the university in Paris-Nanterre, I started learning three basic principles of law. The first one is that EU law prevails over national laws. The second one is that laws are territorial by nature, meaning that EU law applies in the EU. The third one is that contracts must comply with the law. In the last years, I had a close look at various national implementation of the directive. I also had the opportunity to read many contracts from the composers we represent. And what I learned 20 years ago became suddenly very confusing. You may be wondering why. Well, first, because the directive should fully apply today in all EU member states. Unfortunately, this is not the case. Secondly, because some of the national laws are not in line with the directive. We have seen problematic provisions on the transparency obligation in Hungary and Finland, for example. And last but not least, because contracts, in particular buyout contracts, are often used to bypass the law or apply foreign laws to European authors. What is the purpose of having good laws if they can be easily circumvented by contracts? We will address all those questions during our conference today. We will start with a keynote speech from the novelist, moderator, and journalist Nina George, President of the European Writers' Council. She will tell us about her personal experience and the views of writers on the implementation. Then, on our first panel, we will look at the transposition with a report from Ulla Furgal, lecturer in IP and Information Law at the University of Glasgow. I also have the pleasure to welcome Marco Gioriello, head of the copyright unit at DG Connect, who will share with us the views of the European Commission. We will also discuss how collective agreements can play an important role despite certain limitations in EU competition law. This first panel will be moderated by Pauline Durand-Vial, CEO at FERA, the Federation of European Screen Directors. We will then watch 2 video messages from members of the European Parliament, Tomasz Frankowski and Iban Garcia del Blanco. I am very grateful for their contributions and their support to authors' rights. In our second panel, we will look into different kinds of authors' contracts and agreements. In this context, we will also discuss the effectiveness of copyright on a global scale and practices that circumvent authors' rights, in particular buyout contracts. Those contracts, very often subject to foreign laws and jurisdiction, prevent composers from any proportionate remuneration for the use of their works. In a recent EXA survey, we have seen that 53% of our members have faced buyout contracts and that 63% of them have experienced an increase of those contracts in the last 3 years. Such contracts have very harsh consequences on our members' ability to make a living from their artistic profession. I am therefore very glad that the current French presidency launched a discussion on such a topic. And I'm very grateful to have with us today Aurélie Champagne, Counselor for Culture, Audiovisual, Media and Copyright at the French Permanent Representation to the EU. Anselm Kreutzer, board member of EXA and German screen composer, will also be with us, together with Janine Laurent, expert in authors' rights. The second panel will be moderated by David Kavanagh, CEO of the Federation of Screenwriters in Europe. Last but not least, we will conclude our conference with a keynote speech from EXA President Eliane Linval, to whom I wish a very happy birthday today. I would also like to thank my colleague Claire and my beloved interns for the organization of today's conference. And also Brain Prod and la Maison Européenne des Auteurs et des Autrices for hosting us today. Thank you again for being with us, and I wish you all a pleasant conference. Let me now give the floor to Nina George, President of the European Writers' Council. Thank you very much.
Thank you, my dear Mark. Dear Marco Gioriello, dear authors, dear colleagues, dear online and present guests, dear Ulla Furgal, dear Aurélie Champagne, dear book people. The Canadian writer Margaret Atwood once said, "The writer as such is like a dead elk. There are 10 other life forms eating off his body." In fact, we, the self-employed authors of all cultural disciplines, the host organism, are the source of a value chain that feeds 7.6 million permanent employees across Europe, 8 times more than the telecom industry. And this we do within a biotic system. So let's think of me as a dead elk, only for a moment. I am the host organism, nourishing the editor, the proofreader, the graphic designer, the marketing representative, the press officer, the managing director, the in-house lawyers. They are all salaried monthly, socially insured. They get paid holidays payment. In return, I receive a ready-to-read product and distribution. But no direct payment ever for my work. Only a time-delayed share, once, probably twice a year, of between 5 to 12%. Although I am the source of this food chain, I receive the least and at last. It's a rumor, however, that exploiters drink champagne from the skulls of authors. It's coffee. Indirectly, my work also contributes to the state to afford its educational mandate, and this for a minimal compensation. And my work also contributes to that platform fill their pipelines with substance. But for this, they are quite uncomfortable paying taxes on EU territory. And they are even more uncomfortable revealing what exactly they use and how, whether in the B to C sector within shared revenue flat rates, whose volatile turnover shift the risk in full to authors, or in the B to B business. Transparency sounds for most of platforms and portals like an awkward skin disease. I remember I had once an audiobook license of my works that Audible wanted to give to Lufthansa for distribution. And thanks to my very tough lady agent, I had included a clause in my contract that I must be really asked before I give any consent to streaming or pricing models. So few authors know this luxury. It is often made clear that this, to ask for, is an inconvenient administrative torture. So before my work was chained up to the so-called fourth exploitation stage, which is quite near to the cremator, I was asked, and the offer was the following. For long-haul flights for 18 months, for expected 25 million passengers, long flights means more than 8 hours, so enough to hear an audiobook in full, I get a one-off lump sum of 150 euros in total, not per flight. So when I wondered if there were perhaps 3 zeros missing, I don't know, perhaps a misspelling or something in the email, I was told, no, that is usual practice, Mrs. George, and by the way, it's promotion for you. It's exposure. Ah, I see. When I wrote an open letter to Lufthansa, offering to fly for free of charge for 1 year, because it was promotion for them and I would do my best to give them exposure, I surprisingly received no sympathy. So when you are all sitting the next time in a train or on a plane and clicking through the board program, please think of me, and the 150 bucks are offered to authors for millions of usage. As a result, I have terminated my contract with Audible and I'm considered now to be a difficult writer. Yeah, my pleasure. But not everyone wants to be difficult. Blacklisting, surely differently formed in every cultural sector, exists to the point to be really menacing. The so-called contractual freedom for an individual author is in practice, take it or leave it, and when you do not take it, please leave the room. Of course, we are not only the economic elk factor. The American novelist Upton Sinclair wrote that those who want to live forever do not even manage to spend just an hour alone with themselves. They grab culture, because without culture, humanity would not know what is happening to it and why. It would not be possible to achieve civilized coexistence if the humankind lacked the connecting, the Cartesian, the contemplative, this epiphanic understanding of being part of a we, and there's really a meaning why we exist. However, as both employees and food providers to the creative and cultural economies, as well as to a parasite mass of sub-profiteers, we authors do not stand on the sockets of manifold monuments of tribute in the metropolitan cities. Why? But stand before you today to ask for analysis, for action, and to discuss together with you how we can move from well-intentioned to really well done. The Directive on Copyright in the Digital Single Market, and especially here Articles 18 to 23 and Recital 72 in particular, was our hope to be strengthened as cultural elks, where the asymmetry of the food chain begins, turning from a symbiosis into a prey-predator relationship in our primary contracts and then following all the licensing chains. So far, the result is sobering. Almost half of the EU member states did not implement it all, or only a bit, or as copy-paste, or used the flexibility in combinations that led to less effet utile instead of more, as Ulla Forgel will highlight also in her presentation. The European Writers' Council survey on copyright in the digital single market surveyed 46 member organizations within a very comprehensive question survey. It's published today on the website, so if you're curious, just look on our website. But in brief, authors' organizations were not consistently involved in national stakeholder dialogues. Not even half were consulted on a continuous basis. And so all the knowledge, the data gaps on how we work, how we are remunerated, all of these conditions remain. Fracture number 2 was, one of the main intentions of the directive is to safeguard the rights to remuneration. I have good news. The good news is that 2/3 of the organizations we surveyed said that this principle of appropriate and proportionate remuneration was not previously included in the legal framework. So yes, here is progress. But 100% of all EWC organizations surveyed said there was no consensus between authors and exploiters on what exactly appropriate and proportionate means in practice. And if you are now surprised, I would be surprised. EXA, the European Composer and Songwriter Alliance, reports that more than half of composers have been offered a total buyout contract in the last 3 years, trend growing. Concretely, this means also that appropriate and proportionate remuneration is still a distance. But we have also one predetermined breaking point, and this is quite too often. And these are the exemptions from transparency obligations which are granted, so that first exploiters and or third parties are not obliged to provide all data to everyone, even though this is necessary, especially in the rising of digital use, including for state institutions, for radio, for TV, for libraries and universities. But hey, without full transparency, however, no proportionate remuneration or renegotiation is even possible. The crack 4. The revocation of rights will remain a matter of individual contract negotiation, and for sure with the hope of making the principle use it or lose it a common practice. Will this remain fiction? All in all, here now comes my wish list for you. As you are aware of, authors are most often freelance and self-employed people. And without a collective representation or an option for action by associations, or without legislation that established effective enforcement mechanisms alongside a good legal text, the individual author will always remain the cadaver that others are feasting themselves on. Also, this imbalance will continue to exist if two loopholes are not swiftly closed now. The introduction of a right of action for associations and the enabling of joint agreements under the competition law. The European Commission should soon adopt guidelines with the goal to allow common agreements. Those future agreements should include clear obligation like to provide all information along the full value chain or on what is appropriate and proportionate remuneration. Also, a non-compliance should be sanctionable. If it's not, the very best law on paper will remain a teethless paper tiger. By the way, 87% of our writers' organizations of EWC, they hope to sign joint agreements, model contracts, memorandums of understanding, name it as you want to. But there is often no willingness to discuss or negotiate from the other side of the table. Here is, let's say, a certain encouragement probably helpful. For us, the approach of the French presidency of the Council to look at the effectiveness of the European copyright framework is indeed motivating and constructive. Member states shall embrace this French initiative, and me and my colleagues really count on the vision that both the Czech and the Swedish presidencies will continue this works in the name of a sustainable European culture. But then we again need to move further. How can we guarantee that also non-EU companies comply with our rules of transparency, rights revocation, of contract law, of respect for intellectual property? How can we adjust again trust and competition law in a way that authors' organizations are allowed to even only give fee recommendations publicly? It's now up to us all to foster and to understand culture for what it is, in addition to its economic and to the political factor. We are connecting people whose opinions are diametrically opposite to one another. We make it possible to feel, to be felt. We nurture your brief time on this wonderful world, and we are needed more than ever in an era when democracies are under pressure. Thank you very much.
Thank you very much, Nina. I now invite Pauline, Marco, and Ula to join the first panel. Thank you.
Does this work? I don't know. There you go. That's for you. So we will start this first panel, which will focus on the implementation of the 2019 Copyright Directive. I am the CEO of the FERA, the Federation of European Screen Directors, and we are absolutely thrilled to be on board this event with our colleagues from EXA and from EWC and FSE, because it turns out that this unholy alliance of authors that we struck a while back now, sometime in 2015 or 2014, turned out to have quite a few positive results for us in Brussels. And the question is, did we succeed in helping our respective networks into transforming the essay in a way in real life practice? And this is a little bit what Ula will tell us about in the introduction to this discussion with the presentation of her report, which will be shortly published. And Ula, with this, the floor is yours.
Is it working?
It is.
Okay. I don't know. Do I have like something to change the slides with, though?
You don't need it because there's someone doing it for you.
Ah, grand. Okay, thank you. See, normally in academia we have to do all the clicking for ourselves, so I'm kind of used to that. So thank you very much, Pauline. Just to say, my name is Sula Furgao. Normally, I work as a lecturer in intellectual property and information law at the University of Glasgow. I'm also a member of the Create Centre, so UK Centre for Copyright and Creative Economies. And on a daily basis, I'm also an editor of the implementation resource page, where we actually monitor how the Copyright Directive is being implemented. So just a small reminder, if I can, the next slide. So Copyright Directive has been a long time coming. The proposal was tabled in 2016, but we already knew a couple of years before that this is happening. We had quite a controversial legislative process. Finally, the directive was adopted in April 2019 and published and entered into force in June 2019. Member states were given 2 years to implement the directive, and this deadline passed over a year ago in June 2021. I think we all here know that only 3 member states have met this deadline, and we are still deep into the process of implementation of the directive. When it comes to Chapter 3, so just a general overview and something that already has been expressed, this is the first time that the European Union actually intervened into copyright contracts, so something that normally has been a matter of competence of the member states. So for the first time we have this intervention into creator contracts, so contracts throughout which authors and performers contract out their rights to publishers, to content producers, and to similar organizations in exchange of remuneration. And this intervention explicitly recognizes this weaker bargaining position of parties. I'll just place myself so I actually see what I have in here. No, I can do like this. Okay, so just to say that this intervention sets minimum standards of protection, which basically means that member states can support higher protection of authors or retain higher protection of authors that they already have in place. And it also treats both authors and performers equally, in a sense that they are both given the same rights and the same rights. So this intervention, unlike the rest of the directive, does not only cover digital uses, but it also applies to analog uses. So something very different. However, as we all know, it's quite important that digital uses are addressed. All in all, there is quite a lot of interpretative freedom and implementation freedoms left to member states during the implementation process. So now, what is the status? If I can, the next one. So just to be short, and I'm, as usual, I have to apologize to Croatian because Croatia is not on this map. Unfortunately, I cannot find a map that is on a CC license that I can edit. Whatever, I have a bit of an update. So what is the status of implementation of Chapter 3? Currently, we have 14 member states that completed implementation of Chapter 3. Those are the ones that are shaded the most orange, plus Croatia. And the report reflects the status as of 20th May. So since then, we have a vote in the Belgian Parliament, of course, on the 16th of June. However, this implementation has not been yet notified to the Commission, so we do not consider it as finished. So we are more or less halfway done, 14 member states, 27 in total, so 13 member states to go. And now, I will kind of briefly go through different articles and just to say what are the general trends and what is happening with the implementations. So when it comes to the principle of appropriate and proportionate remuneration, usually this implementation, so member states are left with quite considerable freedoms because they are to decide on a mechanism which will realize this principle in practice. So what we see with the implementation is that there is a restatement of principle, and sometimes there are just factors that need to be considered while deciding what is appropriate and proportionate, and they are quite general. If mechanism is addressed, quite common those are collective agreements, but it might be to the extent that an implementation just says, oh, it will be decided in a collective agreement, full stop. So there is not much detail in there. The most detailed provisions we see in Germany, however, those are provisions that predate the Copyright Directive, And we see the copy of those provisions in Austria. So those are common remuneration rules. So an agreement of what is this equitable, so appropriate and proportionate remuneration. That is, those agreements are made by representative organizations for particular sectors. We also see those residual remuneration rights, so rights that stay with authors even when they transfer their rights. We see an example in Slovenia, but there is also a recent example in Belgium. As I have not seen the text yet, I am not voicing my opinion on this one. When it comes to principle of appropriate and proportionate remuneration, something which is very important, so whether a lump sum can be this appropriate remuneration, the directive says yes, however, member states should specify in what cases. Some of the member states, unfortunately, don't even mention this fact. Some mention but have only general provisions. Quite rarely we have a list of situations where this is permissible, and only in one example I found that the list is exhaustive, which is in France. So this is a closed list. When it comes to consequences, what happens when this remuneration is not appropriate and proportionate? Kind of fun example is that in Estonia. So when parties agree on that remuneration, but remuneration is not paid and the use continues, this use is considered copyright infringing. So this is how Estonians kind of approach the sanctions in there. When it comes to Article 19, so our transparency obligation, more or less implementations look like copy-paste of provision. So not much of specification is being provided, especially not what type of information needs to be communicated by the parties. One interesting example and exception from this rule is that from Ireland. So Ireland actually requires that apart from information, authors and performers are also informed of the rights that they have. So this is kind of important that authors and performers or creators actually know what they can do with this information. So they can use, for example, the contract adjustment mechanism because they realize that the money that they are getting is not enough. When it comes to the limitations and transparency obligation, the directive in here allows that in duly justified cases, when we have this administrative burden, the scope of information can be limited. But again, that should be specified by member states. What are the duly justified cases? Member states are not really doing it. They are simply copy-pasting the wording of the limitations. So there is this provision that it might be limited, but it's not really set in what cases per se. When it comes to sanctions, just to be shorter, because I think this is quite interesting, because the only member state that does introduce more of a substantial section of what happens when transparency obligations are not fulfilled is Italy, because it introduces this presumption that if the transparency obligation is not met, the remuneration that creators are getting is presumed not to be appropriate and proportionate. So we have this basis for contract adjustment mechanism to apply, and additionally the Communications Authority can administer a fine up to 1% of annual turnover. So this is quite sizable, but this is the only example where we have an actual sanction in place. When it comes to our contract adjustment mechanism, is quite similar to transparency obligations. So we have majority of implementations following the wording of the directive. So they are simply stating, oh, you have a right to ask for additional appropriate and fair remuneration. Not much of a mechanism is provided, but yet again, we have another fun example from one of the countries. So Ireland, as the only member state that I'm at least aware of, states that if a creator writes to the contractual party saying, I want my remuneration to be adjusted, there is actually an obligation to reply within 1 month, and it needs to be a substantial reply to that ask. And an interesting thing is the personal scope. So normally we are allowed, and according to the directive, we are allowed to ask for additional remuneration from our contractual counterparty. However, in the Netherlands and in Germany, we have this extension to sub-licensees if this disproportion between the remuneration and the revenues is a result of revenues generated by the sub-licensee. But this is something that actually predates the CDSM directive, but something that has been retained and unfortunately has not been followed by any other member state. When it comes to the alternative dispute resolution, I must say that this is something that member states pay the least attention to, as far as I see, because normally it's a simple statement that a dispute can be referred to another venue, and we have an indication either of a pre-existing body or even just a simple mention of you can refer your dispute to mediation. So it's not much of a content when it comes to implementation of this article. And last but not least, my personal favorite, I must say, because I've been doing most of work about right of revocation. So right of revocation is not something that is very new to the European system. We already had this general use it or lose it right in 8 member states, not particularly used, but it does exist. And this right especially suffers from lack of specification when it comes to digital uses. Because we are allowed to revoke a transfer in case our rights are not being used. What does it mean that the rights are not being used in a digital sphere has not been specified by a single member state. So this is a bit of a problematic issue. Something that might be interesting for people gathered here is that audiovisual works are quite often excluded from the scope of this right. However, there is a number of more specific national provisions concerning audiovisual works. So it does not mean that they are completely out of the scope of revocation. It's just this general provision quite often does not apply to them. And just to sum up, very short conclusions. So we have a lot of implementation freedoms that are left to member states, but majority of those implementation freedoms are simply not used. So we have quite a lot of practice of copy-paste of provisions just to kind of finish, unfortunately, implementation, but there is not enough consideration of what freedoms are there, how they can be used, and especially how they can be adjusted to digital uses. And I think that's all from me. Thank you, Ulla.
Thank you so much. It's really very interesting on many levels, but I have to say I've noticed that you're using the word we, and you're not an author, you're an academic, aren't you? Exactly. So you're a part of the family. Here you go. But it's on a personal note, I think that's really interesting because in many ways we struggled for a long time to get contractual issues as something that the academic world in terms of authors' rights and copyright was really focusing on. And I find this discussion, collaboration also on another project that we have with our colleagues from FSE and UniMe super interesting because you have a particular approach to these matters, which is good to have as counterpoint.
Thank you very much. I must say I'm kind of new when it comes to copyright contracts, but it's definitely something that is not being researched that much and something that we are very interested in, especially in the Create Center, as you know. So we will be doing more work for sure.
That's great. Great to hear. Let's turn to Marco for a minute now, or more than a minute. You've heard quite a few things already, from Nina's keynote to Ulla's presentation. What's your first reaction to all of this from the European Commission standpoint?
Thanks a lot, Pauline. Yes? First of all, I wanted to say that I'm very pleased to meet all of you again after a long time, at least in person. So this is already.
Is this working?
Okay, we need to switch closer.
Closer?
No, I think we need to switch.
It doesn't work. I suspected it. Yes. Yes. So I start again. I was saying that first of all, also for the remote audience, I'm pleased to be here actually and meet all of you in person again. after such a long time. Mark was reminding me that probably the last conference I attended before COVID was a conference organized by the same group to discuss, the same topic, and hopefully we can see that some progress has been made in the last 2 years, although maybe not as much as we would have wanted. Now, getting briefly, to some points that I wanted to make before the panel discussion. First of all, yes, I need to confirm that only around half of member states have implemented the directive so far. Of course, let me say that although we may see why this might have happened in some cases, also in the context of the pandemic. For the Commission, this is clearly an unacceptable situation. More than 1 year has passed already. And we have currently infringement procedures opened, I think, against 14 member states for non-compliance with the obligation to transpose the directive. We are already at quite an advanced stage of these procedures, which means that basically for the member states which may still not implement the directive in the coming months, the Commission may decide to go to the Court of Justice and propose the application of sanctions. So this is something which we hope we may have to do only with very few member states, but it will happen if the situation does not improve quickly. So this is a message that I wanted to pass clearly. I think also my commissioner made the same point the other day in the CULT committee. Now, the remuneration chapter, so the topic of the discussion today. I agree with Ul. I think, of course, it's not the first time that we are discussing this, that this is a chapter which leaves a lot of flexibility to member states. And of course, this makes it more difficult to handle at European level. By nature, if there is more flexibility that member states can exercise, it is much more difficult to take a position, at least in legal terms, at European level, as to whether a certain approach is right, wrong, or can be improved, and so on. It was a conscious choice, of course, of the Commission to put on the table a flexible mechanism, basically, in that area. Then I think that additional flexibility was added as the result of the negotiations, as this is often the case. And the main reason why we wanted to keep this subject flexible is largely because of what you have also said, that it is the first time that we're really getting, extensively into copyright contracts. Of course, there are here and there in other directives some specific provisions which already go into copyright contracts, but this is the first comprehensive exercise that we have done. So to some extent, what we have on the table now and the discussion that we're having is also the result of, I would say, the historical moment we were into, basically, back in 2016 when the Commission put this directive on the table, which is really the first attempt, basically, to start a process of harmonization of this area. Now, I don't have a crystal ball and I don't have breaking news to announce, but I think logically we may go more into details at some point in the future in an hypothetical, new round of copyright legislation at European level. I think that the trend is going in the direction of intervening probably more in the future at European level to, in a way, protect the weaker parties, basically, in the copyright market, basically, so the individual authors and creators. But again, this is a personal reflection. Again, don't take it as the announcement of something specific coming. But I think that this is the direction that things may take in the future, and it is also in line this basically, I think, increased attempt to pay attention basically for the individuals, for the weaker parties. It is in line with the fact that I think increasingly copyright regulation is moving from a pure, let's say, private law market you know, I don't know how to put it better. So basically to just, you know, set the rights and the exceptions to the rights and then leave everything else to the market. Legislation, in my opinion, with this directive is moving towards, you know, more intervention, basically to try to find the market regulation and the balance between different parties. And to some extent, I think this is not only copyright, is in general the regulation of the internet at European level goes more and more basically towards this direction, and basically try to find the balance. And overall, I need to remind everybody that at least for us, the overall logic of the copyright reform was fairness, basically. So we have really tried to put on the table a number of provisions to introduce more fairness at the different stages of the internet market in copyright. So this is the part more related to the relationship between individual creators and their contractual counterparts, and then there is the other part, which is basically the relationship with the platforms, which was a little bit inspired by the same idea of intervening to defend the weaker parties. Then, you know, to what extent we have succeeded, I think it is something that we will have to see in due time, and this allows me basically to have another consideration, and then I'm about to finish this first intervention, which is the fact that now we are still, at least at European level, from the Commission level, at the stage of making sure that everybody implements this directive. Then there will be a phase of making sure that what the member states have done is correct, basically. And in this chapter, with all the flexibilities, it may be more difficult than for other parts of the directive to really take a clear legal stance on what is wrong and what is right. And then there is the phase of the analysis of the impact on the market, basically, of all these mechanisms, which probably goes first into try to understand, you know, how the contracts are changing, and then really the real final results on what has happened in terms of remuneration, working conditions, if I may say the word, basically for authors and so on. But the point that I wanted to make is that despite the fact that in theory all these phases are sequential, and this is still a little bit the way we will have to work, so think about implementation, conformity checks, evaluation, I think that unavoidably there are overlaps between the different stages. So while obviously I think it is far too early to draw any conclusion as to whether the copyright directive has worked on the market and on the results and so on, but at the same time, I see that unavoidably we are starting discussing already the impact of the market, actually. And I think it's good, basically. So the message that I wanted to pass in this respect is that we are very interested about the discussion as well. So even if, you know, in a way, from a institutional perspective, you know, there are different steps, and I think formally the Commission will have to present a report in 2026 about, you know, the impact of the copyright directive. But unavoidably, you know, this is a discussion, you know, which somehow, you know, needs to start before, and we are very interested to start having some signals actually of what is happening in the ground. And this is not only about these provisions that we are discussing today, but if you take, you know, Article 15, Article 17, of course, I would say even before the implementation in national laws, a lot of things have happened already in the market, in the relationship between platforms, right holders, publishers, and I mean, this is not the topic for today. So just to say that, you know, we are late, member states are late, so we are late if we're talking about the law. We are early if we're talking about evaluating the impact, but unavoidably we need to have discussions on all these points as of today. So this is my first intervention for the moment. Thanks.
Well, thanks for this, Marco. Oh yeah, thank you. I mean, it's good to see that you're on point and you've thought about it. That's really critically important for us. But maybe just to unpack a couple of things that you said. So I don't think you could find a more welcome crowd to the notion of market regulation in copyright law that the people who have co-organized this conference. Obviously, this notion that a number of imbalances within the value chain needs to be addressed is very much at the core of our beliefs and what we try to do here in Brussels. So voilà, on this, it's always good to hear that this is something that will not go away and will actually be built upon in the future. But more specifically on conformity checks, to unpack a couple of specific points. How do you view, for example, in the very basic challenge that we have today, that we have if I remember correctly, in Article 27, a transitional provision on the implementation in individual contract of the transparency obligation, which actually kicked off a couple of weeks ago, and we have half the member states who have not transposed yet. For us, that raises a question. It means that we have half of our membership who are basically without national legislation framework, and yet who are supposed to have these new rights kicking in. And we have a number of market players who are, of course, tiptoeing around this issue, sometimes in very unhelpful ways. And we have, some very recent cases in Northern Europe, which illustrates this really well. How do you see this? Because this comes way before the conformity check. It's actually a very practical problem we have already in contractual practice.
I expected you to ask me this question, and I studied it a little bit, but it is, from a legal point of view, an extremely difficult answer to give, and I'm afraid I can just give some pointers. So I think, my understanding of the question is what happens if in country X the implementing law has not been adopted yet, while the directive says that by the 7th of June, I think, of 2022, so 3 weeks ago, for example, the transparency obligation should kick in. Now, maybe you have a better answer than me, so feel free to correct me or to complement. I think it's a matter of what is called, at least in my studies, was called the horizontal direct effect of a directive, and there are very few and limited circumstances where individuals can claim that a directive may be actioned against another individual, so against another private party, in the absence of national law. So I am afraid, this would really need to be studied, but I am afraid that from a legal point of view, it may be difficult to argue that a creator could go against, let's say, a contractual counterpart just on the basis of the directive without a national law. At the same time, I think still in theory, there is a responsibility which could even become a liability, basically, for the state in not having implemented the legislation. Now, of course, I'm not naive. You're going to tell me, yes, we're not going to sue the state to get damages, but I think...
At this point, we all could, to tell you the truth, but
yes.
Yeah.
But I think, this is the way, probably European law works in this context. For sure, at the level of member states' obligation, one thing is clear, in my opinion, is that, the fact that a state is late cannot be an excuse to further extend this deadline, basically, because the idea of the June 2022 was to give 1 year, basically, for market players to adapt after the implementation of the directive. So this cannot mean that if national law is adopted in 2022, this becomes 2023. This, I think, is pretty clear. But practically speaking, from a purely legal point of view, I think it is difficult to action, basically, these clauses in indirect relationship. That said, I would have to hope that, but probably you're going to tell me the contrary, that in most cases the environment your members are working on should not be the Far West, which means that I think a responsible reaction by your contractual counterparts would be, to start getting organized to comply with this provision, even if the national law is coming only a few months down the line. But this would be more on a voluntary basis, I think. So sorry for the long, answer on that. As I said, I tried to study it a little bit, but this goes down to general principles of European law, which are a bit complex, basically. But I hope this gives you at least
that's very
a beginning of an answer.
It's very good already as a start. Ula, do you have any thoughts on that?
Just to say, I did not study this issue. However, as far as I know, yeah, it's not directly actionable. There was a case study in Poland, where I'm originally from, as we have not implemented copyright directive. And I think last year there was a discussion in the academic field whether it is directly actionable. And majority of the scholars said, no, it isn't. And if we have some measures already, there is a recommendation to interpret them in the spirit of the directive. However, this is not binding law if it was not implemented. Unfortunately, this is not a good answer, I guess, but...
Well, I mean, it is an answer, which is already very good.
Yeah.
Sounds a little bit like the law is the law, I'm sorry. But
Yeah. Well, I mean, it is what it is. That's fine. To follow up also on the conformity check process, one thing that we were also wondering is to what extent it will be interesting for your services to look into collective agreements, for example, that may have stemmed from the transposition process, because we see in certain countries that the recourse to go into specific sector detailing of the implementation of certain provisions is left to collective bargaining. Is that something that in the future you might look into? Because the provisions, these provisions in the directive have a direct impact on the way our contracts are built, and so do collective bargaining agreements, which are related to it in the transposition process.
Yes, collective bargaining. I mean, I think Nina, you mentioned it, if I understand well, in your introduction, and it's a topic, as many of you know, at the moment. Yes, I think it is interesting for the Commission to look at them. For everybody, for those who may not have read recently all the details, there are several instances where the copyright directive in these provisions that Ula mentioned relies on or gives a space to member states to rely on collective bargaining. And I was looking now, listening to Nina, I was looking, there are a couple of provisions also which explicitly empower trade organizations to act on behalf of the authors. And if I remember well from the time of the negotiations, we added these provisions, in particular I think it was a request coming from European Parliament, to try to cope to some extent for the situation of the risk of blacklisting, basically. So again, I don't know whether we went far enough, but there is a role, the point that I wanted to make, for collective organizations, trade organizations, which trickle down in several provisions of the instruments. Now, strictly speaking, the conformity checks that the Commission will have to carry out, which means basically verifying whether the national implementing laws are compliant with the directive, are going to be directed more towards the legislation. Although, to some extent, you may say legislation may open the door basically to a role for collective bargaining. So, this may become part of that, but I don't think that, in order to decide whether member states X or Y has complied with the directive, we're going to look at the details of the collective bargaining, but we're going to look more at the general framework. But the topic is very important, and the topic is very interesting, I would even say. So definitely, whether it is in the context of the conformity checks or whether it is in the context of analyzing the effect of the directive on the market. So you see, I go back to what I said, the different steps and type of analysis are going to overlap. This is something that I really would like to look at, and so also mean that I'm open with my team to get feedback on these issues as we go.
I think we will have some feedback for you at some point, obviously, on that. But maybe to stay on this, on the collective agreements point, we've heard sometimes at national level arguments put forth stating that competition law was hindering the possibility to use collective agreements as means to implement some of the provisions in industry practice. But we know that the Commission is looking at the issue slightly differently from some work that's been done recently on the competition side. Can you tell us a little bit about that?
Yes, I think you are referring to guidance which are expected to be published by the Commission on competition law and collective agreements. So this is a work which is ongoing. I'm not directly competent for that, but of course we are working with the DG Comp on that, and a draft of the guidance was already published and subject to consultation a few months ago. This is not only about copyright, this is in general about what I think is called solo self-employed, or the gig economy basically. So it covers other type of situations, Uber taxi drivers and similars. But it is very important because I think it's the acknowledgement of the fact that anybody who is working as a solo self-employed basically is in a very specific situation that bargaining power is needed, maybe needed even more today than before because of big players that in the internet economy, in different sectors are of course the counterpart of the individuals. And the reason why we, DG Comp, together with us, is looking at this is because in the past, and I think those of you who worked with us at the Copyright Directive also, you made us aware of this problem. There were doubts as to what extent collective bargaining might run into problems from the point of view of competition law, basically, because it may be considered to be a cartel, basically, because every single self-employed could be considered an undertaking, and then having common conditions could be considered against the competition law. And I remember also, frankly, discussing with some of you who are in the room today, while we were working at the Copyright Directive, this was a concern that was coming. I think, I may say, I cannot talk, for other sectors of the economy that I know less, but I think that these discussions in the context of the Copyright Directive have been very useful to make the Commission aware of the competition law issues that could stand on the way of collective bargaining. And I think you can see what we are trying to do now also as a response to these concerns, and more general as a further confirmation of the fact that we recognize an important role for collective bargaining. Now, I am told that the guidance from DG Comp should be published in the autumn. I know that the work is ongoing. Some of you are probably in direct contact actually with DG Comp, but if not, I'm happy to pass any message to our colleague that you may want me to pass.
Well, I think on our end, the message is the autumn seems very late compared to the super high pressure we feel on the market right now. So, yeah, that's it's good and bad news wrapped all into one. Timing is really of the essence for us at this point, and I think that's been made fairly clear by Nina, and the next panel will also discuss that in more details. And to actually touch upon market pressure a little bit, I think, we from the different organizations who are involved in this conference, within our membership we sense some shifts in contractual practices, and in that, there is the law, there is the directive, there is the transposition process, and then there is the market. We see very tense situation between market players, not only between authors, performers, and producers, but also across the value chain in the audiovisual sector. That's fairly visible. did you feel that in the work that you did on the transposition, Ula? Did you have any sense that market pressure was somehow impacting the process, or is that something that just doesn't necessarily filter from what you've observed?
If it filters into the transposition, I wouldn't say so, to be honest. You can see it's more of a, especially with the member states that are late and are only now getting into the transposition, you see more of an inspiration of, oh, what the others have done, and not, hey, what is happening on the market because of the directive. Especially if you read justifications behind particular proposals, there are direct references, oh, France has done this and that, or Germany has done this and that. It's actually quite interesting because they didn't say, oh, France has done this and that, and this is how it works in practice. I haven't seen that personally, but this is also something that you don't necessarily put into the legal document. So what is happening behind? No idea, because this is 27 member states, so who knows? But I wouldn't say that this is something that plays into the phrasing of law
Of course.
itself.
Okay.
May I add something? I tend to agree. I mean, for what I can see, that unfortunately, to some extent, the implementation process has been taken more as a legal administrative process rather than really, you know, a attempt to go deep into analyzing the specificities in the market in different countries. Then I don't want to generalize too much. For sure, there have been, you know, different ways of proceeding, different exceptions. But I'm saying that because to some extent we are a bit disappointed because we tried to, first of all, make it as clear as possible in the directive. I remember there is a recital talking about the need to have a sector-specific approach, stakeholder dialogues in the implementation of these rules. And we have tried to steer member states a little bit in this direction. I think, frankly, I'm not saying that COVID is the only culprit for this, but this has played a role, because I think we were all starting, basically, you know, to be in the stakeholder dialogues discussion mode, and then what happened, and I think to some extent it has disrupted to some extent this process. I mean, I'm not saying that this would have been, you know, extremely better without, but this has had an impact, so maybe we need to do after what should have been done before. Just wanted to share.
But there are two reasons why I mention it now. One is that in the audiovisual sector, we can feel the fact that the Audiovisual Media Services Directive is implemented pretty much at the same time as the Copyright Directive in certain member states. And that has an impact, clearly, on how the legislator feels free to go in certain directions or not, because we know that there are an industrial reasoning to keep in mind, especially post-COVID. So, there are some market considerations impacting the process that we feel are maybe not always very visible, but still important to keep in mind when you look into, well, next stage conformity check. If you're looking for the explanation, sometimes to certain interpretation, that can be one element. And the other reason why I mention it is because we've known that the French presidency has started work with member states on buyouts and the actual reality of how copyright is exercised to the benefit or not, and with a certain level of efficiency or not for rights holders across the different cultural sectors. And one question that I have for you, Marco, is that we've heard Commissioner Breton talk about a commission report on the impact of buyouts, and I think he mentioned some time before the end of the year. Maybe you can tell us a little bit about that as well.
Yes, so basically, I know that the commissioner announcement has raised the question. So what we're talking about, what the commissioner was talking about, I think, is the media outlook, actually. So for those of you who have been following our work in media, if you go back to the media action plan that we published a couple of years ago, don't remember when exactly, among the different actions, there is this idea of publishing a media outlook regularly. So this is supposed to be a sort of overview of the economics and the market dynamics in the media sector, which is actually something that other colleagues, is again not my team directly, is working on. And it's really a serious evidence-based work that we would like to publish regularly. The first of these reports is indeed planned by the end of the year. I think originally should have been done a bit earlier, but now the target is the end of the year, and this is what the commissioners was referring to. Buyout practices are going to be part of this analysis, but this is not a report on buyouts. It's a report on the media market where there will be, a particular attention on the relationship between streamers and creative industries, and in this context, obviously, this aspect will be looked at. I also want to say that, as far as we are constructing the work on the media outlook at the moment, there will be a general overview, and then there will be a zooming in, and the buyout part will be relevant in particular for zooming in the relationship between streamers and audiovisual producers, basically. So this is, for the time being, the main aspect that we are covering, but after a more horizontal part on the entire media market. But clearly, I think that as this topic is gaining, attention at stakeholders and political level, we see this work as the starting point to some extent. So I think that there is ample space then to do different zooming in on other specific situations, other specific sectors, and also to continue the discussion that indeed I see already we have started in the Council together with Member States about these practices. But basically, this is what the Commissioner was referring to, and it is the media outlook, basically. So it's not a different study, but of course we will deal also with this topic.
I think it's interesting also to remember that when you're mentioning this concern of audiovisual producers facing streamers, the retention of intellectual property at national level, which has, cultural diversity and even I would go as far as saying, because I'm French, strategic autonomy notes to it. It actually goes exactly the same for individual intellectual property owner that authors are, because many times we are sometimes faced in contracts not necessarily in a bargaining power strike with fight with the contractual counterpart, but with the commissioning party. And in that sense, if there is a concern to retain strategic autonomy in terms of IP for intermediaries in the value chain, it's equally true actually for individual authors. So our point is not only one of market regulation in dealing with our immediate contractual counterpart, but also in the grander scheme of things with whomever is commissioning the work. But that's a bit of a side issue. Maybe we can open for questions from the room if there are any. Any brave souls want to ask something directly to either Ula or Marco on anything that was mentioned? I don't see anybody. Oh, Anne, here you go. Maybe if you can introduce yourself for everybody. I think Marc is coming over with the...
So my name is Anne Bergman-Taron, and I represent the publishers. But my question is Marco and Ula. I will pass to my members, and obviously everyone is aware of the directive, etc. But at the same time, we are faced with exceptions which prevent us to remunerate the authors. Because when libraries are using e-books in some countries and are sort of destroying the primary market, the remuneration becomes more difficult. So I'm asking the Commission, very well talking of fairness, but in the same directive you introduced exception, and I hope you're not going to go any further on exception, and I hope the academics will stop recommending further exception to make the access to the market easier, because honestly, this affects the remuneration of authors in a very impactful manner. So it's a different discussion, but it has some implication.
So basically, you're talking about not destroying the basis of exclusive rights on which you operate as intermediaries, which is supposed to trickle down some value to authors, even if sometimes we're not too sure that it actually happens. Do you have any comments on that? Maybe
I
Ula?
must say that unfortunately I'm an academic advocating for exceptions and for them to be out there, especially when it comes to, you know, books being available to students, because I must admit that the prices that libraries are currently paying for books are quite high. So the ebook that the library is getting is not an ebook that a basic user is getting. It's an ebook that is way more expensive. But this is not something that I'm working on, so this is like more of my personal opinion than my very informed academic opinion. But I think I will shut up in here, because I'm definitely not on this side of discussion.
All right, fair point. Marco, do you want to add something from the Commission's perspective on future work?
I mean, you're right that exceptions also have an impact in the entire ecosystem, and so for sure this is an aspect that you know, if one day there is again a discussion about exceptions at European level, I think the impact not only on the publishers but also on the authors is something that you know, you should all remind us that we need to look at. So I think this is clear point taken. Beyond that, of course, copyright is a difficult balancing act. So, you know, there are different public interest objectives that we are trying to keep together, sometimes with good results, sometimes maybe a bit less. You know, everybody has different opinions. The exceptions have an important role to play in the copyright system. This is clear. But I think, you know, it's important to try, you know, to always look at you know, the entire system if one discusses you know, potential legislative reform. For the time being, I can reassure everybody, or not, I don't know if it is a reassurance or a concern, we are not thinking about a new copyright reform, but I'm also aware of the fact, I mean, I think, yeah, like many of you have been in this topic now, I mean, maybe a bit less than some of you, but still for a long time. These discussions are cyclical, so at some point maybe unavoidable that there will be another discussions on exceptions. So I take your point that we need to look at the economic impacts on everybody.
But maybe in a way it has to do with the fact that valuing intellectual property and copyright has gone completely haywire, because the market balances are not the same as they used to be, and maybe it's more a question of seeing how things evolve and where the right leverage points are. I don't think that market going haywire should be an argument for no more market regulation, for example. Maybe not for no more exceptions, but definitely not for less market regulation.
First, let us finish implementation of one directive, and then let's talk about the new intervention into copyright, because we're still nowhere to be done.
Breathing space. Yeah.
Yeah, a bit.
You don't have to follow up, Marco, if you don't feel like it. I can see you like struggling a bit.
No, on the contrary, okay. Because I wanted to say something, but I also don't want to prolong.
Don't get into trouble. That would be really bad for us. No one will come after.
Not say anything.
Okay. All right. A few questions. I think maybe, Nina, if you don't mind, Cécile over there first. If you have a mic somewhere. Yeah, here it goes.
Thank you, Cécile Desprin from the Society of Audiovisual Authors. Ula, I invite you to see the Belgian transposition of the directive. The text is available in French and Dutch for now. But if I would like, I mean, to just mention that it's for us, it's a relief to see this implementation of the directive with two right to remuneration for authors and performers. One, like in Germany, for uses covered by Article 17 on with collective management, and the other one for communication to the public, including making available right. going further than just uses of Article 17. So I guess, Marco, you will have difficulties to comment on that, but yeah, just want to draw the attention on this very interesting implementation for us, because it's a bit good news in a long period of not very interesting implementation law in many countries. So we hope it will give inspiration to the remaining countries who have not implemented yet. But Ula, if you want,
it's on my reading list. I couldn't find it, but this is me being awkward in French and Dutch at the same time, basically.
I think we can help with that.
Yeah, just to, because as we were talking, because that has been approved by the Parliament, but it's not been signed in and published yet. Okay, thank you.
You're good.
Now I really don't want to get into
Okay,
trouble,
good.
Pauline, so I will not say that.
All right, so we have a couple of more questions. Nina, maybe first?
Thank you very much also to Ulla to address all these issues quite clear. And what I found interesting that during the implementation, all the digital issues had been, well, left out a little bit. And this is exactly what we have also to deal with. And yes, Marco, I will bring you in trouble. Culture is something without borders. So Anselm is selling his work also in the US. Me too. I quoted the Audible example and some others. Authors face the problem of so-called non-disclosure agreements more and more. So that portals like Audible, Amazon and others tell my publisher he or she is not allowed to tell me the discount, the percentage of the discount, because I get a share from the so-called net value and the net sales, not from the price. But the net value I get is minus the discount. But any portals said to my publisher, no, please sign a non-disclosure agreement so that the author is not aware from what is my share from, let's say, again, an elk, a beer, a cat. So how do we deal with non-disclosure agreements when it comes to transparency for European authors working in Europe, but perhaps dealing with non-European non-disclosure agreements and non-transparency? What shall we do? Burn them down?
Haha. So the question is basically, we have rights, they apply in Europe. Sometimes we deal with operators who exploit our works outside of Europe, and somehow the new rights that are embedded in the directive don't generate any actual feedback on reporting, for example.
So, a few things. The extraterritorial aspect of contracts, I don't know if I'm really using the right term, but basically, what many people are telling us, that you are concerned about your contracts being subject to the law of some third countries, has partly an answer under European law, as recalled, in the directive. You are aware of that. The private international law basically has different mechanisms which basically allow to bring back the contract to the law of Europe in our case when most of the aspects of the transaction are in Europe. This is of course the legal answer. I think the more and more, and again I refer to the work that we did in the council, we understand that there is the theory and then there is the practice, and in the practice it may also be practically difficult to understand to what extent you can really consider that everything is happening in Europe, because we are having a lot of situation with international players. So just to say that there is something in the legal framework, then to what extent this is sufficient or not is a discussion for the next years, I would say. I think what we are missing now in, these discussions, which are a little bit emerging discussions to some extent. I mean, we talked a little bit about non-disclosure agreements during the copyright negotiations, but not a lot. We hardly talked about buyout contracts, and we hardly talked about extraterritorial application of third countries' laws. So to some extent, these are emerging topics. What we need is more evidence, more discussions with the stakeholders, because, for example, I mean, it would be very interesting to see what publishers, streamers, I mean, the contractual counterparts of the creators think about non-disclosure agreements, basically. So to what extent it's really indispensable to cover up things behind the non-disclosure agreements, to what extent, you know, there are maybe contractual practices which have been there forever, but, you know, maybe they should not be applied anymore. So I'm just saying that, you know, these are all things that we should try to discuss all together with different parties as much as possible, actually, because I have the feeling that we are still a little bit at the beginning of new discussions on this.
I mean, in these new areas, these new issues popping up, I think the good news is that we're going to have tons of evidence for you, like really tons and tons and tons. So you won't be without matière, as we say. But definitely, I mean, these are things that are fairly critical in terms of making a real life difference for individual creators. And in the end, I see you guys making signs, and I have lost my train of thought. Dominique, you have the floor for the question. Go ahead. Maybe
because
Olaf
this
first.
is something
Yeah,
for compliance, for practice, because we do have the confidentiality element in the transparency obligation, and something that I notice when it comes to implementations. Even if an implementation addresses confidentiality, saying all parties can agree or they should keep information confidential.
Which is fairly rare, right?
Which is fairly rare, but extremely rare is a notion that is in the directive that this should not influence creators' ability to exercise their rights. I think that I only noticed that in Austria. So this is something maybe like in the future, because I think that can be done via compliance check, because I found it very disturbing to some extent that we have all this information that in theory should be disclosed. There even is a mention in the directive of the worldwide revenues, I think, in the recital.
Yes, there is.
Yeah, but in the end, like confidentiality, even though it's there, it's not a part of the national implementations particularly. So it is something there. It's not much, I think, but it is something to begin with.
Just very quickly, because I think we're running late.
Different issues, yeah.
When I mentioned the evidence, of course, you know, it was not the usual reflex of the Commission, bring me the evidence, because otherwise I cannot do anything. Of course, we always need the evidence, but generally I would be interested to speak with the other side, so Anne, maybe also with your members, if relevant, so with publishers, producers, streamers, and so on, and understand the reasoning behind the certain clauses of non-disclosure, actually, because I think, you know, I genuinely don't know enough, basically, of the reasons why, you know, these things are in the contract, and then, I mean, of course, I mean, the conformities, yes. Please remind us when we get there. We will look.
Fair points, and I'm sure that that's going to be a very interesting discussion. Dominique, go ahead.
Thank you. Yeah, Dominique, International Federation of Actors. I'm not quite sure whether this is going to be a question or a comment, but just reflecting on the energy and the large stakeholder consultation around Article 17 and how that ended up clarifying to, you know, some extent at least, the content of their provision, and I find it quite a pity, even though there was no obligation in the directive itself, that a similar exercise wasn't envisaged with respect to the provisions of Chapter 3, because as you said, there is a lot of leeway, a lot of flexibility in those provisions, and some minimum guidance as to you know, how countries ought to transpose these provisions in a meaningful way. I think would have put us in a quite different spot right now, even, you know, and what we see from our members is that not only business is continuing as usual, in some countries is getting worse than usual, and, you know, where some of the established practices are being challenged by streamers, for instance, and I think everybody's aware of the situation in Denmark right now. They are threatening to pull out, well, they are threatening to stop, well, they're not threatening, they're stopping all production in Denmark as a result of the Attent Creative Denmark and the Producers Alliance to negotiate fair and proportional remuneration. But in many other countries, the main changes that we've seen are simply a few additional words that are being introduced in the contracts. Those contracts remain buyout contracts, and simply the actors, and I'm assuming a lot of other right holders, have to acknowledge that remuneration is fair and proportionate, and you know that sort of that type of implementation. It shouldn't be allowed. It shouldn't be possible. I mean, it's like it's a slap in the face of the spirit of the directive. And I think having at least some minimum guidelines to say, look, you know, these things, you know, shouldn't be seriously considered, would already be, you know, of some degree of help.
Yeah, let's not. Let's say this was a very interesting comment that
Point
taken. Yeah. So I think we've run through our time. I mean, lots of things covered, and I would be at a loss to summarize in a sentence. But maybe time is short. The market is not getting any easier, and we actually welcome the fact that there is an approach from European institution to really understand market dynamics and informing the process of further development in copyright. We feel like this is really something which is going to help us make the points we've made on principle in the past sometimes maybe more clear in practice for you, and we very much want to believe that, you know, we can do even better in the future, even if sometimes we're a little bit frustrated with how things go at the moment. Thank you so much to you both. And on that, I think you all have deserved a coffee break.
So absolutely. Thank you, Pauline. Thanks, Marco. Thanks, Oula, for joining us. So we'll have now a 10-minute break, and please be back at 45 with the rest of the conference, 2 MEPs' intervention, and then we'll start the second debate. We are a bit late, I'm sorry for that. Thank you, everyone. So we are back here at the conference. Now we'll hear two interventions from two members of the European Parliament, Tomasz Frankowski and Iban Garcia del Blanco. Thank you very much.
Dear ladies and gentlemen, as the EPP coordinator in the CULT committee, it is my pleasure to send you this message and support this conference organized by EXA, FERA, FSC and EWC on the implementation of the 2019 Copyright Directive. This directive is a very important step forward for a fair, transparent and proportionate remuneration of authors and performers. However, today the Copyright Directive is still not a reality in the EU. We have seen important delays across Europe and too many EU member states have not implemented the directive yet. This is a missed opportunity, in particular for the European Parliament, which stressed in several resolutions that there is still a lot of work to be done. There is no more time to lose to improve the working conditions and remuneration of creators. In the meantime, the COVID-19 crisis had disastrous consequences in many different cultural sectors, but has benefited streaming platforms which will continue to grow. I am glad to see that VOD and streaming platforms are thriving in Europe, but they should also respect our laws, including authors' rights, especially when they can benefit from public funds for the production of European audiovisual works. Our European model authors' rights is not only about the protection of intellectual property, but also about providing a fair remuneration to authors who create so they can continue to create. This model must be protected against attempts to impose unfair contractual practices to European authors. Too often, film directors, screenwriters, writers and composers have no contractual freedom and face blacklisting if they want to negotiate and defend their rights. Together with other MEPs, I'm asked the European Commission to take initiatives to prevent buyout contracts where European composers are facing contracts under foreign law that deprive them from any revenues for the exploitation of their works. This is not the first time that the European Parliament calls on the European Commission to act. 3 different resolutions did so. On the Council side, I want to thank the French Presidency for raising this issue. Finally, I also want to thank Commissioner Breton for promising a report by the end of this year on the impact of buyout contracts. The Copyright Directive also encourages collective bargaining agreements between authors' organizations and their contractual partners. However, those agreements are the exception rather than the rule today. This is often due to lack of willingness from the industry, but also often because EU competition law prevents such agreements. Now, the European Commission is moving in the right direction to eradicate the obstacle of competition law. Once this is done, there should be no further excuse to refuse collective agreements and a fair and proportionate remuneration for all creators. I am delighted that this conference can provide a state of play on the implementation of the directive, but also provides a long-term vision for the future of European authors. Together with my colleagues in the European Parliament, we will continue working towards a fair remuneration for creators. Because without creators, there is no creativity, no culture and no creative industries. Thank you very much, and I wish you a fruitful discussion.
Non-EU based VOD platforms that impose buyout contracts on composers in the EU. Such contracts, which are most often subject to US law and jurisdiction, deprive composers from any royalties based on the use of their works. This is a clear circumvention of EU and national laws in Europe. As European Union lawmakers, we cannot accept that the laws we adopt do not apply in the European Union or only apply on case-by-case basis. I also want to thank the French presidency for putting this issue on the agenda of the Council. It shows that buyout contracts are widespread and growing in parallel with the development of big EU streaming services. I really hope that the European Commission will also propose solutions to prevent those contracts. Together with the Cultural Creators Friendship Group, we will continue to promote better creators' working conditions and a fair and transparent remuneration for their works. We wish you plenty of success with today's conference, that I'm sure it will be a key milestone to reach this objective and foster a sustainable future for European authors and their creativity.
So thank you, Iban and Tomasz. I'm sorry there was a bit of a technical issue with the speech of Iban, as you may have seen. We'll try to solve that and show it later. Now I'm glad to open our second panel for discussion, and I'm going to ask David Kavanagh, CEO of the Federation of Screenwriters in Europe, Aurélie Champagne, Counselor at the French Permanent Representation to the EU, and Anselm Kreutzer, EXA board member and German screen composer, and Janine Laurent, expert in authors' rights. This debate will be moderated by David. So David, the floor is yours.
Thank you. Do I have to say again that my name is David Kavanagh? I'm the Executive Officer of the Federation of Screenwriters in Europe, but I think it's been said once or twice already, so you get who I am. I am Irish, as you may get from my accent. I made a phone call a couple of weeks ago to the Intellectual Property Unit in the Department of Trade and Industry in Ireland, and I was having a conversation about a question that's not relevant here. And there was an efficient and competent and very available, accessible person on the other end of the line who tried to help me with my problem. We were getting on quite well together, and at a certain point she heaved a big sigh and she said, "Oh God, I hate copyright." And I completely get her point. I had to tell her that I agreed with her substantially. Once you get past the first surface, it becomes mind-numbingly complicated. 27 different member states with different approaches, all of our different sectors with different approaches. Even inside those sectors, there's radical differences from one end to the other. There's exceptions, as we were reminded. It's insanely complicated. So I'm very grateful to Nina for reminding me of what we're actually here for. As Nina described the circumstances of individual authors and how they try to make their way through life, I know that all of my screenwriter members, without exception, would have completely recognized and acknowledged exactly what she's saying. We have arrived in a situation where Europe's authors share in common the fact that their contracts are terribly bad. They are badly paid, badly treated, and live in a career that is so unstable that 90% of the people who start out to become authors fail and leave the business before they get 1 or 2 years into it. 80% of feature films are written by an author who never writes another feature film again. Why not? Because they can't survive on the money that flows from the contract that they've signed. They leave because it's an impossible industry. How have we arrived in a situation where a culture and an industry that fundamentally depends on human talent treats that human talent so appallingly badly? And from my perspective, I take your point that it's an issue of fairness, and Marco repeated the idea of fairness. From my perspective, it's not so much an issue of fairness, it's an issue of efficiency. What incredible stupidity to build a culture and an audience based on human talent and then treat the human talent so badly. It's stupendously inefficient and wasteful. But as I say, once, I've made those remarks once or twice before in my life, and once I get past that point, I start to become very confused when we start to get into details. So I'm very well served today by a panel of 3 people who know a great deal more than I do about the subject, and hopefully their erudite answers will cover my lack of knowledge. In particular, we're delighted to have Madame Aurélie Champagne here from the French presidency, the councillor and therefore chair of the presidency committees across all of the areas that we're interested in. And Aurélie, we're particularly interested to have you here because the French government has acted, the French presidency has acted on the question that we're interested in. We also have Anselm Kreutzer, who is a member of the board of EXA and a member of more or less everything in Germany associated with it, including being on the Works Committee of GEMA, a very powerful music CMO in Germany, as you will all know. And my old friend and colleague, Janine Laurent, who has a very illustrious career, having worked both in SACD in France, the Audiovisual Collective Management Organization, and with Sky in Spain, which deals with music as well as audiovisual, but has also worked in marked contrast with that system of managing copyright in the United States with the Directors Guild of America in Los Angeles for a number of years. And is now a consultant and is involved in a wide variety of interesting tasks, including with myself and Janine and Pauline on various items that we're trying to discuss. So I'm going to start, Aurélie, if it's okay with you, by asking you about this very interesting initiative of the French presidency. Now, of course, we understand that it's confidential, it's not yet published. So we're not going to ask you terribly detailed questions. You're not Marco Giorello, and we don't spend our whole time trying to put you on the spot. But perhaps, I mean, the very fact that the French presidency took up the issue of buyout contracts already suggests that there's an impression at government level that this is an issue. So maybe you could give us some commentary on the general response that you got from the member states when you contacted them. Whether there was some kind of agreement among them in broad sense that there is a problem that needs to be addressed. And most difficult of all, whether you see any prospect of further action to address the problem, if indeed it's seen to exist.
Bonjour à tous, et merci de l'invitation. I'm going to, of course, keep on in English, because I understand that it is a setting we're in. It is great to be here, and it's great to be able to give you a few insights on what we did for the last 6 months in the Council, which is a very confidential institution usually, but it doesn't mean that I can't say things about what we did. So the first question is, why did we choose to undertake a brainstorming, some sort of a brainstorming within Council on the issue of the effectiveness of the copyright framework, and why did we choose then to write a report? Well, I have to clarify a few things on the objectives, because like you mentioned earlier in the previous panel, and as was said repeatedly, the European Directive on Copyright introduced several provisions on the remuneration of creators and cultural industries. And our objective was not to measure the implementation of these provisions, because this is a job for the European Commission, and also because it was a little bit too soon to get into that, because, as you know, the transposition is not yet fully done in all member states. And so what we were aiming at was trying to address some new topics, which were a little bit off the radar, as Marco said, and that we felt like were important, because like I think we've all witnessed, and it was mentioned also, that with the COVID-19 crisis there was an increase in demand for cultural content, online notably, and we had the impression that this new demand was not benefiting creators in a proportionate way, at least not as much as we would have expected. And we received reports talking about the way many works were not paid because many stakeholders were trying to use exceptions in order not to pay and not to recognize the existence of copyrights. And we also had the impression that some new models were pushed by some actors, both on tangible and intangible property, but also on remuneration, and like was clearly stated by the European Parliament and the two MEPs which just intervened, this was a practice which was raised by Parliament as a matter of concern. And so when we were preparing our presidency, we were like, okay, maybe it's the right time to address it. We hadn't had any talks before between member states on it. And so we were like, okay, maybe this is the right time to try to address it at technical level and try to get a better understanding of what the problem is and the extent of the problem, and also maybe try to contribute to debates on possible solutions. And so what we did was sending a questionnaire to all member states, touching upon these issues, and notably on the circumvention of European copyright rules and attempts to impose new models. And our target was to encompass all practices which have a loss of useful, which means that there is a loss of useful effect of the EU legislation and national legislation, because as you mentioned, there are differences across member states, and I think that all the reasons for which you don't like copyright are the ones that I love. But well then. So it was not only illegal practices, it was all kind of practices, meaning a loss of useful effect. And we received many contributions from member states, like more or less 2/3 of them. And some were able to give us clear-cut positions on what they were thinking, and others were more giving what their CMOs or professional organizations had given them, because many launched national consultations in order to answer the questionnaire. And we also had debates in the Working Party, which were very constructive, and also take the opportunity to thank all of my colleagues, which worked a lot in order to answer and talk with us in the frame of the Working Party. So now, as regards the results and possible recommendation, all member states have observed the practices we were aiming at, so practices trying to circumvent the application of copyright, and also practices of attempts to impose new models. And one was in particular reported repeatedly, and that is a buyout, which is, from what we understood from the answers, mostly exercised by large international platforms and search engines established outside of the EU, which is a common assessment here. And these platforms and search engines try to impose bundled, undifferentiated remuneration for all the creation. And usually, as was said, they do so via contract, choosing notably to have the contract governed by foreign law. And then, not all member states have witnessed the same practices. They report difficulties to assess how frequent they are. But however, they do share the assessment that these practices are like a really unbalanced model of ownership of tangible and intangible rights and remunerations. And we launched something which was cross-sectorial. So it gave us the opportunity to kind of measure that it seems that these practices are more common in audiovisual, music, and also the editing sector, whereas some others are a bit less under the radar. A majority of member states said that they were in favor of exploring solutions at EU level to a reasonable extent, which means that many of them also told us that we had to take into account what the copyright legislation enables us to solve, what the DSA and DMA may change in the market structure, and also to take into account contractual freedom. So it was a mixed assessment between, yes, we want to look for something at EU level, but we really also have to articulate it with everything which already exists. And the form of solution was not determined, but we had several suggestions which were made, and notably on buyout, it was suggested to stipulate that such provisions diverging from our model cannot be implemented on a territory of a member state or that foreign law cannot be applied when the work has been produced within the EU, that we can't have these clauses that make it possible to circumvent our laws. And another one was maybe we could make EU and member states' aid conditional to the respect of our framework. And some of these solutions already exist in some member states, so we would be maybe going further on with something at EU level. I have no clue how long I talked, and maybe I talked too long, I'm sorry. Just two things. We conclude to the necessity of further investigating the subject, and maybe we'll go on later after about the study the Commission announced. And finally, I wanted to say that our report is going to be public. Some preparatory documents leaked in the press, as they always do. And we do intend to make it public because we feel like it is important in order to have EU debate going on and not keeping it to ourselves.
Thank you. I mean, from my perspective, that's absolutely fascinating on a number of levels. First of all, the fact that you initiated it, thank you very much. Secondly, that you got such a wide response from the member states. And thirdly, that there seems to have been broad agreement among them that there is a problem which needs to be addressed. Maybe that brings us back to Marco, who has had to go to another meeting, so he won't hear me saying this, and the issue of guidelines about the implementation of aspects of the directive, which might be something that comes up again as we go along. Because certainly, Anselm, to come to you, I think we in each of our different sectors, we see both that there is continuing abuse of contracts, but also that it's becoming more widespread and more aggressive, that buyouts seem to be much more common at the moment. Now, my personal instinct is that these buyouts are certainly coming from global companies, but they're also coming from European companies, big and small. And I wonder if they're learning tricks from the streamers that they're now applying themselves in practice. What's your experience? In particular, maybe you'd start with trying to define exactly what a buyout contract is in a way that we might all agree.
Yeah, thanks, David. That's also already a tricky thing, the buyout contract, because there are many different notions of it in the world. So it's not perceived as the same thing in the US and in Europe and in certain countries of Europe. I think basically when we're talking about buyouts here, we're talking about full buyouts, so including remuneration for all future exploitations of a work. So one lump sum has to cover everything, the commissioning fee, the license to the work, and all future performing rights, mechanical rights, exploitations of all kinds. And as we all know, this is not possible. It is not possible to estimate the future success of a work. So one work of music might be a chart song which is being played a lot of times and the other one just fails, and who can one know in advance? And if I do a score for a TV series, how could the producer know that this series will be exploited a lot of times or just a few times? So just take speaking about the practical point of view, when I started growing into the business in my mid-20s, I got the first opportunities to compose something for a big German commercial TV broadcaster. And the first approach was like, well, you're young and you don't have much experience and you now get the chance to pitch in with your work, and if you win, don't expect too much remuneration because you're young and, well, anyway, this show is gonna be considered like a pilot, so it will be on air for a week, maybe with the title melody. And so, well, in fact, it turned out it was on air for a whole year on a daily basis. And, well, I got some commissioning fee, but it was very, very low. But in the end, I got my GEMA royalties because this was considered non-negotiable back then. It is still at current state, but it is circumvented more. So I didn't have to worry about that more than 20 years ago. And this was the only way to grow into the business and to have a chance to do a second thing like that. We talked about the book authors who probably write for one film, the screenwriters, and don't do another film again because remuneration is not worth it and it just doesn't work out in life. So the long-term success of a work cannot be foreseen, but buyout contracts, as we speak about it here, are a tool to circumvent remuneration rules as they are written down in copyright law or author's right law. So that is basically the thing, and as you were saying, it comes from global companies, and it is pretty clear. I just want to elaborate on that. What is the difference between a local or a national TV broadcaster and a worldwide acting streaming service? Actually, the system of ongoing royalties is to the benefit of producers in linear TV and radio, because they are not the ones who have to pay the royalties later on in other countries. So if the show I was working for in Germany is then being sold to Italy, to France, to other countries, the same company doesn't have to pay these royalties. The other stations have to pay, and this all adds onto it. So if the company would like to pay me with a lump sum, they would have to pay much more than they actually have to, and it would be to their own disadvantage. If a company acts on a global basis, subsidiaries of the same company are in place in every country, and they are the ones paying the royalties, so there is much more interest to get rid of that. This is the nature of it.
Do you see in these contracts the word buyout written in the contract, and it explicitly says this is a buyout contract?
Sometimes it says it, and in many cases it's not written down. It's just the meaning of the contract. So you give all rights you have, including future exploitation and whatever. It doesn't say buyout.
Do you see the phrase work for hire appearing in contracts now?
Yeah, that's also a tricky one because it's also different. The American notion of work made for hire is different from the, for instance, German notion. If in Germany someone writes work made for hire, it basically means a full buyout, including all future royalties. And so in America, it's a little bit of a different story because work made for hire means that the composer, just speaking about composers here, is not entitled to any share of the sales of the product. This is not what we get anyway. So this is not preventing them from getting performance royalties and so. So it's a better notion in the US as compared to Europe.
I'm going to come to Janine. I think we can describe ourselves as friends, Janine, can't we? And one of the reasons why we are friends is we both have a horrid fascination with reading authors' contracts. There's something fundamentally wrong with both of us that we... So, as was mentioned earlier, increasingly now when you go to read an author's contract, first of all, it might very well have a non-disclosure agreement in it, a written formal non-disclosure agreement. A Netflix contract, and obviously I can't have read a Netflix contract because it's got 2 pages of non-disclosure agreement material in it. How do I know that? Because I must have read it in the contract, right? But in a huge number of cases, authors don't want you to read their contract because they're embarrassed about the contract that they've written. They know it's problematic. Janine, let's exchange horror stories on contracts.
Okay. So thank you for having me. So my specialty, although I worked in music also, but my specialty and what I'm talking now is about writers and directors of audiovisual works. So coming back to the copyright directive and the provisions on contract, it's a big victory, and congratulations to all the organizations who fought for this and to the Parliament, the Commission. But even I believe, with my experience of learning, seeing contracts, I believe that even if in each member state we had the implementation of strictly every article, if you don't have a strong organization representing writers and directors, if they are left alone, then it's the survival of the fittest, and that's not the way you want to build an industry, especially when you need so much content right now. So what are buyouts, to continue about what Anselm says? It looks like, since we talked today, that it came with streaming, not at all for writers and directors. And even for, let's say, my main career was in Europe and France. What does it mean, a buyout? It means even for a French writer or director developing a movie for 2 years, he gets a payment which is generally an advance payment on future royalties. Within the French territory, he or she will get royalties. But what happens when it's a big success? Always it has been like this. Then the film, as Bertrand Tavernier was saying, when you sell your movie abroad, it's like abandoning your child to the welfare system. You never know where he is or she is or the film is. Because even if the French contract had a mention of proportional remuneration, very rarely, the director or the writer would see the outcome. I remember a big animation movie. In order for the writers and directors to get their 0.05% of the worldwide sales, the movie should emit several billions, which was impossible. So when suddenly the streamers came, so basically you export your movie, you don't see anything. Only in France, and then in Germany, they didn't have anything, the writers and directors, not even from their own local broadcast for a long time. Then came the streamers, and they put blatantly in front of us what the system is they say, hello, La Casa de Papel, you'll get everything in Spain, maybe a little bit in Italy for the writers and directors, but all over the world, look, nothing, because the buyout system exists, except that now you have a global company. So when I worked a long time, as you said, on this system, and producers would say, and by the way, it's normal that producers say, I don't want to pay, I'm poor, I have no money, you just have to fight, and you manage to get something. I'm very optimistic. But people would tell me, oh no, but you know, the Americans have the right system, they have buyout. And so I worked for the Directors Guild of America, I went to Los Angeles, and I learned a lot about the guilds. And it's an amazing system. I don't think we could apply the union system in Europe. It's their culture. But basically, before internet and now with the streamers, writers and directors have always, thanks to the collective bargaining agreements, each one is about 500 pages and covers from the first line written by a writer until the exploitation all over the world. Before internet and now with the streamers, all members of the Writers Guild of America and the Directors Guild of America get paid for when they develop and then when the movie or the TV series is exploited all over the world. They have a special system. If you remember about this famous non-disclosure agreement, we had a meeting where the Writers Guild of America was in Berlin. And somebody in the audience says to the representative of the Writers Guild, but how come you can give us all these figures? You don't have an NDA. They say, well, I'm not going to say the word they say, but they don't care, no NDA. They publicize all the figures. So it's very important to have a strong organization representing writers and directors. And guess what? Where I've been working, the US, France, Spain, good laws, strong organization, and a thriving industry. It doesn't mean because you have a good protection that the industry is dying. Look, Spain is becoming a hub. I'm sure La Casa de Papel writers got a better deal after the success of the first season. But we're going to talk about it later, I'm sure, and about the importance of collective bargaining and to see the creativity of, may I read? So this clause is in a contract after the vote of the directive and proposed to a European musician in a country where the law is wonderful. So with respect to territories or jurisdiction where the transfer of future forms of exploitation or means of dissemination is not legally permitted, the production company will have an irrevocable and exclusive option to acquire these rights from the musician for the pre-agreed price of €1. The acquisition of such rights will be carried out automatically after the delivery of the corresponding notification to the musician. So, and this was after saying that it should be proportional. I think that when you're, as you say, when you're author and you receive this, of course you say no, but it's quite insulting. So you definitely need collective bargaining, as we'll see later, to help implement this wonderful 3 or 4 articles in the directive.
I read a contract yesterday, and so I think you mentioned contracts like this, and Sam, which was also done after the passage of the transposition of the directive. And this is the transposition of the directive in this particular country. So the lawyers, obviously, for the producer had carefully read the law and had rewritten the contract to get around the law. And it said, you know how much money this project is likely to make on the market. Therefore, you know how much money you're likely to get. Therefore, that's proportionate. Therefore, you accept that this is proportionate, and you will not ask for any other monies other than the monies in this contract. Another little horror story is the work-for-hire thing in Netflix contracts. The work-for-hire thing in Netflix contracts, in one sense, is logical. It's Article 13 of the Berne Convention on comparative treatment in different states. And it says any state in the world where work for hire normally applies, this contract will be work for hire. The only country in the world where work for hire actually applies as a matter of law is the United States. It then went on to say, if work for hire applies in the United States, you, the writer, will not be the author because you'll be employed on a work for hire basis. The producer will in fact be the author. So who is entitled to ask for information under Article 19? The author. The author is now the producer. So the writer is now, by this trick, unable to seek information about the exploitation of their work supposedly permitted under Article 19 in the United States, where it's most likely to have made the largest sum of money. There are lists and lists and lists of these tricks being introduced into contracts at the moment. An incredibly complicated one, which I had to read 2 or 3 times, was one that said, we're reintroducing the idea that you can audit the producer's income as the writer. You can send in an auditor. But you have to agree that you will not audit the last 12 months under any circumstances. Why? Because the information that's to be provided under Article 19 is to be provided every 12 months. So you're now in a position where whatever information the company gives you, you have signed an agreement that you will not audit it. So you cannot find out whether they're telling you the truth or not. There's just constant string of tricks like this to try to get around and I think one of the things I'm saying here is that it's not just the global streamers. It's our friends and colleagues near and dear who we work with, who, as Dominic and myself are chatting with, we are doing our best to defend in the row in Denmark at the moment. And it's increasingly problematic. What are the solutions? One of the questions that I wanted to ask when Ulla was here, and maybe I can ask it now, is in Article 19, there are 2 provisions which were quite properly inserted by the contractual counterparts. One is the administrative burden, and the other one was the size of the contribution that an author could make. So producers, publishers are entitled, and it's perfectly sensible, it makes sense to me, to say it's too much work to provide this information for you. And the other one was, this person has made such a small contribution to the work that they shouldn't receive this information. It's not relevant to give an extra on a film information about the income on the film. Ulla, if you're there, were these actually referred to in any sense during the transposition so far?
So, just to clarify here, do I have to use the mic?
Yeah, please, yeah, because it'll be recorded.
Sorry, just to say, yeah, they are used, but they are copy-pasted.
So yet again, we have duly justified cases. If admin burden is too, no one specified anything out of that. When it comes to significant contributions, I think there are 2 member states that define what is considered a significant contribution, and they sort of build that if it's non-significant, it does not have an impact on the economic success of the work, and it could be substituted by contribution of another person. That's kind of the vibe that I've seen so far. Was that? Whose mic was that?
Thanks, Pauline. Sure. You and me back. So, Anselm, if we can, do you think we have arrived in a situation where we have described the nature of the problem sufficiently well?
Yes, I think so. I mean, a lot comes from the confusion of copyright and author's right, because copyright you can sell to someone else who could even be considered the author. I don't know if it's that easy with all the moral rights includes. If they're all waivable in the US, it's still a tricky thing in the US, so it's a perky kind of contract, and it shouldn't apply in any way in Europe. But as always, practice is stronger than any law and any convention and everything. If the companies hiring composers like me just do that again and again and again, they say, well, we might lose a lawsuit, but that's all calculated in. So the risk of losing everything is not that high. That's just not a level playing field. So the composer is in the weaker bargaining position. And that's why we need collective bargaining agreements. Also, solving the problem, you mentioned that it might be indeed too strenuous to provide all that information. In certain cases, it may be true, but if you have collective bargaining agreements, that should solve it, because you have like a model for it and how you could provide information in what terms and what could be paid. So the system we as composers have with the collecting societies is actually pretty good, despite the fact that more and more companies, especially in video games and so, say, well, we don't want to work with guys like you, because our rights are exclusively attributed to the collecting society in Europe. And then some producers say, okay, you're not a composer I can work with, because I want to get those works out of the system and I want to make a full buyout. So there's really a split in the composers right now, not only in Germany, also in other countries, depending on what profile they have, for what kind of company they want to work. And this is really a situation I think politics should face, because it cannot continue like that, that you are young and have to make a decision. Many composers then don't become members of collecting societies just out of some fear, because they don't know what happens later. Later they say, okay, this was a fault, because I now see that it would have worked out, but they don't have the experience. So there should be a solution that what the law says, that there is a right to equitable remuneration in all cases, should be the reason for saying that the system like GEMA and SACEM and others, collecting societies, is just exercising this kind of law. And it's nothing that could be circumvented anyway, so there is no fault in dealing with them.
Janine, you've worked in both systems very deeply. What would your view be on the balance?
Well, it's different from music, because you have a network of collective management organization all over the world that can collect for you. I remember some French directors who had their movies all over the world say that the musician would get more money than them, because you don't have a network like this. And very few countries, in fact, for writers and directors, have an equivalent of GEMA or SACEM. Plus, even for screen composers, writers, directors, you have two time. You have the development process, which you should pay, and then you have the exploitation. And when the writer and director transfer their right to the company, they have exclusive right. They transfer for the duration of copyright plus 70 years after. So it means forever. It doesn't mean that the producer gives away. The producer will sell, and then the right holder to the producer. So it's normal to associate writers and directors. But in many countries, this has to be done by a collective bargaining agreement because CMOs will always only go to cable retransmission, private copy, and not the primary right. So, plus, there are things that are done in the contract. I always say the CMO, because I was at SACD, we arrive after all the pain that you suffered for 2 years of having the production company asking you to write and rewrite for free, because that's also something that the collective bargaining agreement deals with, is that how many times a writer can write for free the same script. So this has to be done by collective bargaining agreement, and both CMO and collective and unions or guilds can work together for the better benefit of all creators.
Do you see a contradiction between the two systems?
No.
Can they
No.
live together?
Yes, yes. I don't know who says otherwise, because one comes after and one is before. So I don't see how they can compete, and they are the same. The writer who is a member of the union is a member of the CMO. So for me, it's the same. It shouldn't be. There are enough problems. If we are divided, who wins? The network or the platform who says, "Oh, it's too complicated. We're not gonna make a deal if you fight each other." But for me, it's different interests. One of the best examples is Spain for audiovisual. They have an excellent law with an unwaivable right to remuneration, which has to be paid for any use of the work by streamers, broadcasters to a CMO. But they have a strong writers' union who does collective bargaining agreements for the writers. So they do both at the same time, and it's working perfectly.
I think we're coming towards some kind of conclusion among the three of us, if not the rest of you. So we'll give you an opportunity to ask some questions if we have a few minutes at the end. How are we doing, Mark? Are we okay for time?
Yeah, sure.
Yeah. Aurélie, can I go to you first? We heard a fascinating announcement from Commissioner Breton that he would pay attention to this in the report that's coming up shortly. This is your achievement, I guess, that you persuaded your countrymen to pay attention at the level of the Commission. Do you have any more information or any comments or any sense of what's happening there?
Yeah, sure. Maybe first I wanted to react to what Anselm said about the fact that some players push authors not to be represented by a collective management society. This is something which was also said in the brainstorming we did with member states. So that is also a practice which we pinpoint in the report as being problematic. Then on the announcement that Commissioner Breton did, no, we didn't pressure the Open Commission to do so, but we are very glad that he did this announcement. It is very good news because, as I said earlier, sometimes we have trouble understanding the extent to which these practices happen. And I'm very sorry to say that, for example, me, with all the lobbying I've been confronted with, I've never seen a contract. Never. And usually we have trouble understanding how they are written and how unbalanced they are. And so this is something we should keep on studying and also trying to study on the frequency of it. And in that perspective, to reflect on what the media outlook could give us, maybe there are some questions. I have ideas. Like how many of the cultural production that one author did in the last year was involving a system where they wouldn't keep the majority of IP rights? Or maybe how many were produced via a commissioning system, or how many of the works were paid only with a lump sum? These are questions for which some of the professional organizations gave us some figures, notably the EXA, but we don't have them for all sectors and we don't help them for all practices. And this is something that we would very much look into in depth and maybe the study can help us do that. Maybe another point I wanted to add is that the work we did was mostly at technical level within the framework of a working party, and it was not endorsed at political level. However, in April, we, the Council, adopted some conclusions on a European strategy for the cultural and creative industries ecosystem. And in that conclusions, you find some political objectives which are being defined, and some of them refer to copyright. And so I'm not going to bore you too long with what the Council said, but still it was about protecting right holders and ensuring fair remuneration, also guaranteeing transparency on operational data, which is something we mentioned, and also like having a more favorable framework for enterprises within which to efficiently manage their intellectual property rights, or some sort of a copyright data infrastructure. And then we talked about conditionality for aid, and Council said that we had to encourage the implementation of policies that would include fair remuneration for right holders between societies, between enterprises, and the fact that this fair remuneration could be taken into account in public financing. So there are first political stance on the topic, and we are going to keep on working hand in hand with the European Commission and with all member states, of course, and with the incoming presidencies, of course, in order to act on it as soon as possible.
I hope you won't mind my saying that those of us who read the Council plan some time ago tended to be a little bit cynical about it and to say, well, that's all very nice to say, but nothing's going to happen. And what's great is that you have actually made something happen. And it hasn't just been a statement from the Council, it's actually something that the Council is paying attention to. So thank you very much for that. Anselm, do you want to say something in conclusion? Some few words to...
Well, we touched on many issues on the legal side and the circumvention of European law by applying European copyright law, American copyright law in Europe. I want to mention something that is somehow beyond the scope. We always need to raise awareness of fair practices, also in regard to producers, TV stations, streaming services, and so, because there are many ways of circumventing we didn't touch on. For instance, European companies hiring composers from all over the world who are not protected as well as we are, making a music library out of that, just offering some small flat rate model, and the European broadcasters take advantage of them. And this is something that is not covered by what we have discussed so far today, but it is a huge problem, and it should be faced somehow, that the producers in Europe and the exploiters in Europe have some responsibility, and that this is some kind of circumvention. And there should be something that is done on another level than just the legal level, because I know it can be done, because they actually know what they are doing, and that this is circumvention of good practices, but we have to keep an eye on that. That's maybe my conclusion here.
Jenny?
I was going to say that these streamers, and not only streamers, we are in a global world where content is available globally. They think globally. It's up to creators to think and act globally, exactly as you said. We have to think globally. But I'm also very optimistic because they need content. It's not like Netflix can just sit and put their machine. They need content, so it's a tough period because there are lots of competition between them, but also they are in so much need that I think the writers, directors, composers should feel strong within their organization, create new organization to fight, and think globally.
So I would be happy to take your erudite and intelligent questions and pass them on to people who know better than I. Anybody? Mark?
Yes, thank you, David. I just wanted to ask something to Aurélie. is that the Council is working usually with trios of presidencies. And so France is the first one of the trio, which also includes the Czech Republic and Sweden. Do you think those countries would be likely to continue the job that you've started?
So I'm going to be very respectful of the initiative which resides in the end of all presidencies, and so I won't give you whatever trio partner could do best than the other. It wouldn't be appropriate, and I'm pretty sure they're going to follow up on it both. What we did was a very large exercise because of the conference topic, I only addressed part of what we did, and notably one other part that we were talking about during the working parties meeting was the question of how to raise intellectual property, not level, but in all the world having a better ambitious protective framework for all authors throughout the world. And what the majority of member states said was that we had to take every opportunity that when the EU negotiates free trade agreements, for example, with other states in the world, having ambitious provisions in the free trade agreement regarding intellectual property so as to raise the level everywhere and not just, regulate for our own territory and then not care about the rest of the world. And so many topics were addressed in it, notably the RAP case, which may be of interest for some of you, the question of free trade agreements, the question of circumvention, etc. And so what I believe is going to happen now is that incoming presidencies are going to follow up on some of these topics, maybe not all of them at the same time, but still. And so I'm very confident in my trio and also other presidencies after them.
More questions? I'll point at people and tell you to Burak, if you don't put your hand up, I'm going to ask you to ask a question. I'm very aggressive like this sometimes. It's the Irish in me.
Thank you for all the interventions. It's more than a question. Actually, I think this is a good opportunity to tell everyone again here who are sharing a common perspective in terms of this issue, that to come up as much as possible from the authors, from your expertise, direct with them, to bring more of those contracts to the attention of the policymakers. So we've heard today that, Marco said that they want to see what is written in those contracts, and also it has been said that they are not so much seen, but there's a reason why they are not seen, because they are usually secret, or they are usually signed because in a way that they've been imposed on the authors, so they cannot put it out. But I think we should join forces to find a way to present more of them, to show more of them, and that aspect of saying that we don't have the evidence is no longer a pretext to not to do anything further on that.
In my experience, every author would prefer to sign a bad contract than to sign no contract at all. And this is our weakness. It's our fundamental weakness as a sector. Nina, are you encouraged at all by what you've heard?
Indeed, I agree, David. The thankfulness of authors is the business model on which publishers and exploiters build their business. So when it comes to contracts, be assured, Aurélie, also the EWC will do his part, and you will be overfloated with contracts and findings next year. And perhaps after that we will all go together in a sort of rehab because of this reading and findings we will have. To sum it up, I would like to thank Anselm especially for the difference you made up. What is a buyout? Because we have to be very careful and be reliable. There are full buyouts, There are total buyouts. There are sometimes buyouts that even probably make sense. That is also possible. It hurts to say that, but if we want to stay reliable, we have to do that. I would also love to say, thanks to David, you bring charm into politics. Indeed, and I am carrying out for you the service to regard all the social media, and they are all following you very closely. And sometimes there was only a sigh. You are working so hard, everybody, for copyright and authors' rights, and most of them, they would love just to do their art and not get in trouble by reading a contract. But there's a huge thank you that you are doing it. So the authors who wants to do art and culture and save the world in a way can focus on their art.
So I get to, Mark, you come in last of all, don't you? So, but I get to say a few words more to finish this panel, I think. This chapter 3 of the Copyright Directive has some very interesting provisions in it. Provisions about transparency, provisions about proportionate remuneration, and the prospect to renegotiate your contract if things go well. And all through it, it suggests that this is complex business. The details are extraordinarily problematic. A win on one side is potentially a loss on the other side. It's quite a complex situation. And the drafters came up with this idea, I think, from people in the Parliament, that collective bargaining between the people involved, discussing it between the people involved, might actually be a solution. And I would like to appeal to the European cultural industries that collective bargaining for the effective implementation of Chapter 3 is a route that's in all of our interests on either side of the divide. It's as much in the interests of producers, publishers, broadcasters, as it is in the interests of authors. And we really need, especially as Ulla so carefully explained, the directive has been implemented in a cut and paste way with the details left to be worked out later. We need to take the responsibility of working out those details. And I would hope that we can do it by a process of collective bargaining, making sure that it's implemented effectively and that all of the hard work of the European institutions in putting it in place will not go to waste. Mark, do you want to say some closing words? Is it you who says them? Is he even here? Oh, there you are, Mark. Sorry.
No, well, thank you very much. I think these were two very interesting panels. I'd like to thank each of you for bringing the discussion. We would have a bit more time for one last question, if someone... No, I don't see anyone. So, thank you very much. Now, I'm sorry again for the technical issues that we had. So, we're going to put again the message of Iban Garcia del Blanco in its full version, and then we'll listen to a speech of our president of EXA, Eliane Linval. Thank you very much.
The European Parliament had a key role for the adoption of the 2019 Copyright Directive. At the time of the discussions on this directive, our political group has always passed for the best possible provisions for creators. Now, Articles 18 to 23 are key to achieve a fair remuneration in exploitation contracts for authors and performers. We are thinking particularly on creators who are in a weak contractual position when they sign contracts for the use of their works. For us, it is therefore essential to monitor in the implementation of the Copyright Directive and make sure they deliver real concrete benefits to all authors and performers in the EU. I want to thank you, in special to EXA, for organizing this conference, for inviting me and the Cultural and Creative Friendship Group to support. This conference is another opportunity to hear from policymakers, authors and experts about those provisions and how they are implemented in practice. In several resolutions, the European Parliament stressed the importance of this directive and asked Member States to engage rapidly on a faithful and ambitious implementation. We also called on the European Commission to monitor closely the situation and launch infringing procedures where necessary. However, the situation is still not satisfactory today, since more than 10 EU member states have not implemented the directive yet. This delay and the COVID-19 crisis exacerbate the current unfair situation for authors and performers. Streaming platforms are booming, but authors are not getting fair revenues from their works. That's why I call once again for an ambitious implementation without delay. However, implementing the directive is only one first step to improve the contractual positions for authors and their remuneration. We also need to see more collective bargaining agreements between authors' organizations and their contractual partners, as encouraged by the directive. Today, I want to call on publishers, producers, platforms and broadcasters to engage into more agreements that can deliver a better remuneration and improved working conditions for authors. I also want to stress that buyout contracts should not be allowed across the European Union. Together with many other colleagues, I have alerted the European Commission about those contracts. Indeed, appropriate and proportionate remuneration for authors is a cornerstone of the EU authors' rights regime, as reflected in Article 18 of the Copyright Directive. This principle is being seriously challenged by the coercive market practices of non-EU-based VOD platforms that impose buyout contracts on composers in the EU. Such contracts, which are most often subject to US law and jurisdiction, deprive composers from any royalties based on the use of their works. This is a clear circumvention of EU and national laws in Europe. As European Union lawmakers, we cannot accept that the laws we adopt do not apply in the European Union or only apply on case-by-case basis. I also want to thank the French presidency for putting this issue on the agenda of the Council. It shows that buyout contracts are widespread and growing in parallel with the development of big EU streaming services. I really hope that the European Commission will also propose solutions to prevent those contracts. Together with the Cultural Creators Friendship Group, we will continue to promote better creators' working conditions and a fair and transparent remuneration for their works. We wish you plenty of success with today's conference, that I'm sure it will be a key milestone to reach this objective and foster a sustainable future for European authors and their creativity.
Hello, all. On behalf of the European Composer and Songwriter Alliance, I would like to thank all the speakers, attendees, and everyone who has watched this conference online. I would have loved to be there with you, but a nationwide strike here in the UK has prevented me from taking the Eurostar and even getting to an airport to be able to join you. So we will have to do with this instead. I want to thank the Federation of European Screen Directors, the Federation of Screenwriters in Europe, and the European Writers' Council, in particular, for supporting and co-organizing this conference with us. Our cooperation and collaboration to defend and promote authors' rights started a long time ago, and I am so pleased to see that it's thriving. EXA is also very grateful to the Creative Europe program and the Cultural Creators Friendship Group for supporting this event. I also want to thank MEPs Ivan Garcia del Blanco and Thomas Frankowski for their inspiring interventions. We know what this copyright directive owes to the European Parliament and that we can count on you to support European authors and their rights. And last but not least, I'm very grateful to the French presidency for shining the spotlight on contractual practices, in particular on buyout contracts. I cannot stress enough our support for this initiative and what it means for all composers in Europe. We hope it will inspire the European Commission, all European countries, as well as other countries across the world to do something about this practice. And you can count on us to bring contracts and evidence to the table. Unfortunately, we have plenty of them. As we heard during the first panel of the conference, the Copyright Directive features a unique intervention by the EU into contractual law for authors and performers' contracts. This was very good news, but it has still not delivered its promises to creators across Europe. Much remains to be done. Even worse, we fear that contractual practices will continue to circumvent the Copyright Directive and its requirement of appropriate and proportionate remuneration. How can we explain to a composer in Europe how her elected representatives adopted a law, but that this law does not apply to her contract? Or even worse, that her contract is governed by foreign law and under foreign jurisdictions? What can she do? Do we expect her to fly to California and defend her rights there? How could she even afford a flight, let alone a US lawyer? Imagine if such a situation would apply to you as a consumer, with your bank or your internet provider. Would that be acceptable? Creators' rights are workers' rights. They're human rights. The directive should also lead to more collective agreements between authors, organizations, and their contractual counterparts. But EU competition law still prevents those agreements in many cases. When our member organizations intend to publish recommendations to their members on fees and rates, they get penalized and fined by competition authorities, even if those are only recommendations. How can we justify this when authors are experiencing fierce competition amongst themselves while also facing a market dominated by very few companies, most of them located in the US? As the gig economy has grown across our continent, the EU has acknowledged that the workers within this sector, such as Uber drivers or casual workers, need to be protected from exploitative practices. These protections should also extend to us working in the creative sector. After all, the gig economy gained its name from us. Competition, or rather the lack of competition, is a huge concern in the music industry, and in particular in the music streaming economy. In the UK, but also elsewhere in Europe, streaming is now on the political agenda. For years, and this has only increased during COVID, we have seen a huge growth of streaming revenues that go mainly to record companies and streaming platforms. Music streaming is booming, but it doesn't benefit songwriters and musicians. Let me give you one recent figure. The global recorded music market grew by 18.5% in 2021, driven by growth in paid subscription in streaming, according to the IFPI, the body that represents record labels. In contrast, one of my co-writers had a gold record with a big female group in the UK. And when she asked to get a copy of the gold record to put on her studio wall, the record label charged her 250 euros for it. And that was actually more than she made in streaming royalties for that gold record. Another example, my friend Emily co-wrote a song for an up-and-coming band that gained about 500,000 streams. 500,000 streams is not easy to get. The money she made from that didn't even cover the babysitter she had to hire for that day when she went in to work with the band. As you can tell, this is an unsustainable environment for creators. We calculated that if I've co-written a song with 2 other people, I probably would make about 150 euros for 1 million streams. That's 1 million streams. Why is this? Well, in today's streaming deals, the value going to the recording rights and the record labels is still often 4 or 5 times higher than what's going to the author's rights. In some instances, even higher than that. As a result, music authors' rights In other words, the value attached to a song has been undervalued. This loss of value for the song is also often due to the fact that the music majors, who act as both record labels and music publishers, usually favor the recording rights to the detriment of authors' rights or publishing rights. This is because they make more revenue out of recordings, where only a small share, if any, is usually paid to the artist. On the other hand, when it comes to publishing rights, to the author's rights, the publisher gets a minority share of the income. So you can imagine which part of the equation that the labels will favor. Those conflicts of interest have a very harsh impact on songwriters and explain to a large extent the very low level of remuneration I just gave you. Music majors continue to seek to suppress authors' royalties in favor of their record labels' interests. EXA strongly believes that policymakers and competition authorities should look into how these companies' vertical integration has created an industry rife with conflict of interest, where the same company essentially is sitting on both sides of the negotiating table when negotiating streaming rates. A lot of the times the record label will also have shares in the streaming company. We urge policymakers and competition authorities to prevent those conflicts of interest and fight against the negative effects of concentration in the music rights sector. Today, 3 music majors use their market power to get preferential treatment and dictate the rules of the game. They also do so on the value of a stream and at the distribution of revenues to rights holders per stream. Despite their huge economic importance, the functioning of the streaming market remains opaque for music creators. This applies to algorithms, curated playlists against payment, preferential treatment of presentation on the platform in exchange for royalties, even on what basis we're getting paid. All-encompassing non-disclosure agreements prevent us songwriters and composers from being able to conduct proper audits. We have no idea on what basis we are being paid, and so it's impossible to know if we're being paid correctly. More transparency in the streaming market is also necessary to improve metadata and be able to verify usage reports. We propose a minimum viable data requirement for all songs that appear on digital platforms. In addition, there is still much to be done to root out fraud and manipulation of streaming figures, including fake artists or bots that keep streaming a song day and night. In short, music streaming must be fixed. To do so, it must be put on the political agenda again and again until we have a functioning industry that supports those delivering the core product, music. Music lovers can enjoy music at a very affordable price, and streaming is booming. But unlike many other industries, it is completely unregulated today. And we are left at the mercy of deals on which we don't have a say and are not even allowed to know what they entail. I grew up in Sweden and started my career there. I've lived in the US and in the UK. It was a proud moment when the EU Copyright Directive was approved in 2019. It reconfirmed to me that Europe values culture and those working within the creative sector. Us Europeans have a rich cultural heritage that needs to be protected. But we also need to support young creatives who are carving out a career today. Copyright is the engine of that creativity. It's what enables us culture workers to express our own unique talents by allowing us to make a living from our work. Copyright is the engine of free speech. That's why countries with strong copyright protection are also flourishing democracies. Copyright gives us the freedom to choose who we want to go into business with. Copyright spurs innovation, and copyright is a human right. If the pandemic taught us anything, it's that music film, books, and art give us solace and comfort in the toughest of times. They're all medicine for the soul. Culture workers and authors are the scientists spending their days and nights developing, through trial and error, the spiritual remedies needed to pull us through these hard times. Let's make sure the Copyright Directive delivers on its promise to ensure that copyright can continue to spur these creative innovators working across our continent, even in the digital age. Thank you all for helping us do so today and in the future. Thank you.
Thank you very much for being with us. Now, it's not the end of the conference yet, because you're all invited to a cocktail. That's why we put the heat on in this room, which is just there around, just in front, actually, just here. Thank you very much. It was a pleasure.